We begin this week with the historic arrest and arraignment of Donald Trump. He faced a federal judge in Miami Wednesday and pleaded not guilty to the 37 charges related to documents found at Mar-a-Lago and obstruction. The detailed indictment lays out the story of a man who willfully kept national defense information without authorization. And a reminder here, national defense information is information that the U.S. intelligence community has determined would pose a risk to the national security of the United States if it's retained or disseminated without authorization. And those first 31 charges are based on 31 individual documents that Trump allegedly kept without that authorization, including information about nuclear capabilities, military weaknesses, and plans of attack.
Instead of getting justice and instead of getting democracy and all the things that you want, it's just the opposite. But it is an absolute two-tier system of justice, no question about it.
But others don't see it the same way. Trump's former Attorney General Bill Barr says these charges are very serious.
I was shocked by the degree of sensitivity of these documents and how many there were. And he kept them in a way at Mar-a-Lago that anyone who really cares about national security, their stomach would churn at it.
The magistrate judge overseeing Trump's hearing this week said that both he and his alleged co-conspirator and personal aide, Walt Nauta, can be released on their own personal recognizance. That means no cash bond in this case. And the judge also instructed both not to talk about the case with any potential witnesses unless it's through counsel. Judge Eileen Cannon, who's been assigned to oversee the case, has ordered that Trump's attorneys work with DOJ to get the proper security clearances in place by Tuesday to keep things moving along. So let's dive deeper into this with a friend of the show, Professor Jessica Levinson from Loyola Law School. Professor, thanks so much for joining us.
Oh, it's great to be here. Great to be back.
I want to ask you a question about some of the evidence in this indictment, because a lot of it relies on Trump's attorney, Evan Corcoran, and some of his personal notes. Now, typically, that information is privileged. We've talked about on the show the crime fraud exception, but a judge in Washington, D.C. is the one who ruled that that evidence could come in because of the crime fraud exception. Is there a way here or a possibility that that wouldn't necessarily apply, or that Judge Cannon could come down differently?
Absolutely. And I think this is one of the places where you see it really matters who your judge is. So Judge Eileen Cannon issued a ruling in a previous iteration of this case dealing with whether or not the former president should get a special master to review some of the documents that were uncovered by the FBI at Mar-a-Lago. She, in my mind, made a ruling that was not based in the law. It was also in the mind of the conservative 11th Circuit that her ruling was not based in the law, and they reversed that ruling, all of which is to say, yes, I think that she could, like all other federal judges, she could make a big difference, and she won't necessarily defer to what that federal judge in D.C. already found, which is there's a reason that we have that information from Evan Corcoran, and that is that the crime fraud exception to the attorney-client privilege applies. He reviewed a lot of evidence to make that determination, but it's entirely possible that she could come out the other way. And I think your question is exactly right, which is potentially the most damning parts of the indictment include that information from the former president's attorney, and that's why it's such a big deal as to whether or not that evidence goes to the jury.
Let's also talk about something called the Classified Information Procedures Act. It's a little bit of a nerdy, wonky thing here, but it's going to govern how they deal with classified information that needs to be used as evidence, and that also could be used as a part of President Trump's and Walt Nauta's defense. How does that work when we're talking about classified information at the center of a case that the jury will need to look at, that maybe members in the public will be in the courtroom, that the judge will be looking at, that lawyers will need to be looking at? Are they all going to get eyes now on what is this really important classified information?
So the answer is yes and no, and we don't know, in the sense that this is why a classified documents case is just more difficult, because the whole point, or part of the point, of why this information does not belong to the former president is that this is government information. These are government documents, and only certain people should see this information. That's why, as we just saw, Attorney General Bill Barr saying, I was really surprised by the sensitivity of the information. So part of what we already saw is that Judge Cannon has said, when it comes to the attorneys in this case, as you said, by Tuesday, tell us that you have national security clearance or you're getting national security clearance to be able to look at these documents. The judge, of course, can look at these documents, and the government and the defense are going to have to sort out how they can provide this information to the jury, understanding that it's a jury of our peers, not a jury of our military intelligence peers. And so you will be seeing that documents are blacked out. You will be seeing the jury basically read in only when they need to be, and fights about how much information is actually conveyed to the jury. That's why sometimes the government doesn't always move forward on cases like this, because you have to publicize at least some of the information.
And you have to get the intelligence to community to be able to verify some of this. Let me ask you here at the end, much like the White House counsel is counseling the office of the president, not the man. And so the privilege doesn't necessarily apply to the individual. We're talking about here documents that belong to the office or really belong to the American people and not the man individually. But there's a pushback argument that we've seen from some folks saying, well, the Presidential Records Act means he could designate them all as personal records. Clinton kept some tapes in a sock drawer. What do you make of that kind of defense?
It's just not applicable. If that's the defense, then we don't have a strong defense here. So when it comes to the Presidential Records Act, absolutely, there's broad latitude. For instance, if you get a letter from the prime minister and you as the president want to keep that as a memento, you can do that. But that does not apply to classified documents, to highly sensitive documents. It would simply make no sense that the Presidential Records Act would basically just be able to erase all of the provisions and all the laws that we have about classified documents and highly sensitive documents. Again, it's like being charged in a burglary case and saying, well, what about the antitrust law? It just doesn't apply.
Good comparison there. That's helpful for folks regularly following this case, but not as steeped in the law as you to understand it. Professor Jessica Levinson, thank you so much for making it plain for us, as always.
Thanks for having me.